work, but I wanted to like remind listeners in the beginning about like what it is you're doing in terms of your strategy for moving forward climate justice work.
Yeah, absolutely. So for the last decade, we have been implementing a strategic litigation campaign exclusively on behalf of young people seeking judicial protection of their fundamental rights to a livable climate system. So, we are the only nonprofit law firm in the world that represents only young people, and all of our cases are against governments who operate and create and fund the systems that are causing climate change. So, whether it's energy systems, transportation systems, those decisions that government make are continuing to result in high levels of greenhouse gas emissions. And so, our theory of change is that once courts recognize that young people have constitutional rights at stake in the climate crisis, they will then declare what those rights are, declare that government must either protect them or not violate them, depending on how the constitutional language is framed, and then order governments to bring their systems into constitutional compliance. And that can come in a variety of different ways. They could declare certain policies and laws unconstitutional if they promote fossil fuel use. Or it can be something more in terms of requiring them to come up with a plan to reform the systems that are causing the harm. So that's the nature.
Let me say this back to you to make sure I understand it, because it really is, for people that aren't legal wonks, it is a tad bit wonky.
Yes.
And at the same time, for someone who is a legal wonk, it's fucking revolutionary. So you, as an attorney, are representing the rights of young people to a livable world, a livable environment. And you are suing governments because of the ways that their transportation policies or their energy policies are infringing upon that right.
That's right. That's exactly right.
So it reminds me of a time when litigators were filing lawsuits on behalf of women's rights and on behalf of the rights of people of color. So when did you get this idea that you wanted to move through case law this new recognition in the US Constitution?
Yeah, well, people who are unfamiliar with the law is in many ways a copycat field. And you see that in the form of legal precedent, what the courts decide us beforehand guides what happens in the next go round. That's sort of how law evolves and shifts. Very rarely in the law are there big momentous changes, massive shifts from here to there. That rarely happens in the law. There's usually much slower evolution along whatever the legal issue is. And our founder, Julia Olson, was very inspired by the civil rights movement. So, for example, the cases leading up to Brown versus Board of Education, when those cases first started to be filed, a lot of them were defeats. And it took about 13 years to build the legal campaign up to the big win of Brown versus Board of Education. And then in the context of women's rights, it was very similar to the context of environmental cases, where there's been climate change cases being litigated for over 40 years. And very little progress had been made because they were mostly framed in terms of individual projects that caused climate change. So a permit for a coal mine or something like that. And that just did not get at the systemic kind of change that needs to happen to address climate change. And so that's why we really took inspiration from civil rights and constitutional lawyers, whether it's in representing children of color in Brown versus Board of Education, or what Ruth Bader Ginsburg did with respect to women's rights in that campaign, and also the gay marriage campaign as well, and LGBTQ rights, and sort of how that legal campaign has evolved. And young people don't have political power. If you're under 18, you can't vote. They typically don't have the financial resources to lobby politicians. And so that's why they are our clients in the cases that we bring.
So give us a sense of the landscape of your legal challenges currently.
Yeah, currently, so we still, our longest and biggest case that we've filed is called Juliana versus United States. And that was filed in 2015. And we just, I'll use air quotes for celebrated the 8th anniversary of that case, because that's far too long for a case to be happening without ever having gone to trial. And that's largely because of the tactics of the Department of Justice under both the Obama, Trump, and Biden administrations, now continuing to fight these kids and ensure that they don't get their day in court. So that case is continuing. We're hoping to get to trial in next year, but we'll have to see how Biden DOJ and the court treats that case. So that's one of our cases. We also are litigating cases in several states, including Montana, Hawaii, Utah, Virginia, as well as we have cases in development in a number of other different states. And then we support cases in countries around the world. So for example, in Canada, we support a number of youth in a case called La Rose versus His Majesty the King that was just argued in the Federal Court of Appeal in February, and a decision in that case will be coming down anytime. And then, in the international realm, we are participating in a number of climate cases that are in front of international tribunals as well.
So again, wanting to go back to the personal, it sounds like somebody at Our Children's Trust sort of was inspired by the civil rights movement. How did you get drawn into the work?
Oh gosh, that's a good question. It ended up, it's the work that I have to do, and here's why. So I was raised by Professor Bill Rogers, who recently passed away in April of this year. And he was one of the founders of the field of environmental law. And he filed one of the first petitions to ban DDT, testified on all of the major environmental laws. So I knew from an early age, he would always tell me that you're going to be working on climate change. You're going to be working on climate change. And so when I had just had my son. So my son, William, was about, maybe 1 year old. Julia Olson and Mary Wood invited me to Eugene, Oregon, to discuss this, this legal theory that Mary Wood had developed, and sort of the legal campaign that Julia had envisioned. And so we all came together, and we all had very young kids at the time. I remember I brought Will with me, and I had a big shopping bag full of toys and books, so that, when I had this meeting in the room, there's Will with all of his stuff, on the ground, so we can have this meeting. And Julia asked me to create a litigation manual, because Professor Mary Wood at the University of Oregon had developed a legal theory, really groundbreaking, thinking about how can we address climate change on a systemic level, knowing that young people and future generations are most at risk of the harms of climate change. And so we took her legal theory and said, okay, if we're going to file cases in different states, what is the theory? What are the likely defenses? How do we get jurisdiction? And so when Will was really young and I was working part-time, I had my own firm at the time, I ended up writing the litigation manual, sort of a how-to, you file these cases. I mean, I would be horrified to look at it today as we've learned. I was about to say,
can we post it on the website?
Oh, good Lord. Oh, good Lord. You learn the most in law from failures. Wins are useful, but you really learn a lot more from your failures. So that's how I got started. And then after the Juliana win in 2016, where Judge Aiken in the District of Oregon for the first time recognized that there's a fundamental right to a climate system that sustains human life and liberties. And that was the first time any judge had recognized a climate-specific fundamental right. And then Juliana was supposed to be headed to trial. And so they needed an attorney with some additional trial experience. And so Julia asked that I join the team. That was about 7 years ago. And at the time, I was doing mostly environmental enforcement work, a lot of agricultural pollution, against concentrated animal feeding operations, protecting in-stream flows for people and fish. I adored that work. But this was just work that I had to do and couldn't say no to. And it really is a marriage of environmental law, constitutional law, civil rights, and children's rights specifically. So it really brought together a lot of my interests, and I've never looked back since then.
So give us the picture of the future if you guys prevail.
Yeah, so here's the future. What we'd like to see is universal recognition of a fundamental right to a climate system, recognized in, when I say universal, I'm saying that all courts around the world would recognize that such a right exists. And there would be declarations of law in place defining what that means. And how that should be defined is what scientists say is needed to avert the worst effects of climate change. And scientists have developed, what can be called a scientific prescription for the planet. And that's, we need to reduce greenhouse gas emissions to below 350 parts per million by the end of the century. And courts are now starting to adopt that standard, including in a concurring opinion in the Hawaii Supreme Court by Justice Mike Wilson. So as long as you have courts making those declarations of law, that needs to be in place in order to finally get the political changes and the policy changes that need to happen in order to get us moving in the right direction. So that's really how we gauge success, is getting courts engaged in declaring and protecting young people's constitutional rights. And legal systems differ around the world, so that takes many different forms and shapes. But that's how we measure success at Our Children's Trust.
Is there any constitution around the world that inspires you in terms of the rights it enshrines for young people and the environment?
Yeah, I think there's pieces of different constitutions. In terms of protecting children's rights, the Montana Constitution specifically protects children and calls out children as needing special protection. So that was very unique in the Montana case, and one that I think should be emulated around the world. I know many other countries also have children-specific constitutional provisions, like the Constitution of Brazil. And there are other constitutions, which I think, if we protect the rights of children, everybody else will be okay. So there's a reason to really focus on protecting children. And I think some constitutions, including Montana, Brazil, really get that right. Other constitutions are really designed to protect environmental specific rights, or the rights. And I would point out the Hawaii Constitution as being one of the strongest, not only in letter, but also in form. It's really been implemented and upheld by the courts of Hawaii, largely because of an extraordinary environmental group of attorneys on the islands who have really been very strategic and coordinated in the cases that they bring under the Hawaii Constitution. And they have developed, some of the strongest public trust law, as well as some of the strongest law with respect to the right to a clean and healthful environment that the Hawaii Supreme Court acknowledges includes a right to a life-sustaining climate system. So clearly inspired by Judge Aiken's ruling in Juliana.
So for those who aren't familiar with the branches of government and how they interact and why a judicial strategy is necessary to complement a political strategy in terms of passing laws or creating policies and programs, Why do you think a judicial strategy is required to make political change possible?
Yeah, well, courts play an integral role in our system of democracy. So you have the legislature is enacting laws. You have the executive who's charged with implementing the laws that the legislature enacts. And then you have the judicial branch who makes sure that the Constitution is followed, whether you're writing laws or you're implementing laws. And you see that in a number of different contexts. Most recently in the Supreme Court with the voting rights case, where you have in Alabama, where you have legislatures drawing political maps that are found to be unconstitutional and violative of people's fundamental rights. And the courts step in and say, that's not okay. The court's not going to tell you, exactly what needs to be done, but they set the bounds for what's constitutionally permissible. And I think what people forget oftentimes, because civics, for most of us was quite a while ago, but the constitutions didn't give us rights. We entered into the Constitution to constrain what government can do. We have natural and inherent rights to life, liberty, property, equality. And we created these constitutions to make it clear what government can and cannot do. And so that's what really we are enforcing. We are saying, government, you cannot enact policies that effectively kill your own children and destroy the natural resources upon which humanity depends. So a constitution should stand in the way of that kind of government conduct. And without that constitution, it's a very different system of government that we're faced with.
So it's hard to have this conversation without immediately tapping into, I think, a sense of despair that many folks feel about the state of government right now in the United States and the level of corruption that is existing and the way in which corporate business interests have eroded the quality of our environment and our livelihoods. And most recently, the Supreme Court has been the site of, I think, what many people feel is like the impact of that erosion. And so how do you, as a legal activist, pursuing what is going to be a multi-decade strategy, continue knowing that the Supreme Court is largely representing the interests that are destroying the environment you're trying to protect?
Yeah, I mean, I think that's a question that all lawyers struggle with, because what is our role in upholding democratic institutions? And courts play a pivotal role in that place. And we also have ethical obligations with respect to, respecting the rule of law and the processes. So we are using the legal system, but there are flaws in the legal system. So a big part of our work is working to ensure that our democratic systems are in place and upheld. And that's in part by, when you participate in the system, you're making sure that that happens. Now, with respect to the Supreme Court, I mean, that's a challenge that we all face. And what we do is strategically think about, how can a climate case be palatable to the Supreme Court? Because we know eventually when we win Juliana, that's going to be getting up to the Supreme Court. So I think we are working very hard to figure out, how does that get upheld when it gets in front of that body? And but the corruption is incredibly challenging, and I'm very hopeful by actions that people are taking, like Senator Whitehouse is taking, to try to get ethics back on board, because most courts have a code of judicial ethics, that they're a code of judicial conduct that they're required to follow. So I'm hopeful that, I think we've swung so far to the situation of the public being so dismayed by what's happening in the Supreme Court that hopefully we will swing back and see some form of ethics being imposed. And the other thing that gives me hope is, my clients are all young people, and I think they really recognize the corruption, and I'm hopeful that they will continue to work on the system reforms that need to happen. But, those are challenging questions that I think all of us face, no matter what area of law we're working in. It's really, really challenging. And we have to do everything we can to maintain these pillars of our democracy, or else, we no longer become America and we become a very different place.
So why don't you give us a recap then of where we're at with each of the cases within the United States? And I do have a curiosity about, I know you've prevailed at the state level in many of your venues, but how that impacts federal law too.
Yeah, sure. So starting with Juliana, I have one of my clients created like this incredibly timeline with all these points, and it's such a complicated case. 8 years of procedure up and down. We've been to the Supreme Court twice, the U.S. Supreme Court twice. We've been to the Ninth Circuit Court of Appeals, over 5 times. So we've constantly been up and down. But ultimately, where we are is in 2020. The Ninth Circuit Court of Appeals recognized that these young people were being injured and that the United States government was a substantial factor in causing their constitutional injuries. But they said, well, even though that's the case, Article 3 federal courts lack the power to do anything about that. We disagreed with that decision. There was a very strong dissenting opinion that took that to task as well. But in light of that decision, what we did was we filed a motion to amend our complaint to take out the request for relief that the Ninth Circuit had problems with. They said a court couldn't order a remedial plan to address the climate crisis. So we said, okay, we'll take out that request, and instead we'll just ask the court to declare the law. So declare that these young people have fundamental rights at stake, and declare that the government's energy system, fossil fuel-based energy system, violates their constitutional rights. So we filed that motion to amend our complaint in June of this year. In June of 2023, Judge Aiken granted that motion to amend our complaint. And so in a normal world, you would be back on the track to trial. But this is climate. And so instead, Biden's Department of Justice have filed a motion to dismiss, a motion to stay the case, and again are asking that the case go up to the Ninth Circuit Court of Appeals before the youth even have an opportunity to present on their evidence at trial. So that's problematic. It's very hard to decide important constitutional questions without an factual evidentiary record, because you're thinking it in the abstract, and there are complex scientific issues in this case. And so if you don't have the science in front of you, it's very hard to make those determinations. And that's why usually appellate courts much prefer a trial record when they're hearing and deciding these important questions. So that's our ultimate goal in Juliana, is to get to trial so we can have our experts and the young people testify in open court, subject to cross-examination, what they're experiencing, how the climate is being harmed, and why the U.S. government should be held accountable for that. So
Is that your only federal case?
That is our only federal case at this time. We have others that we're currently developing, but Juliana is our only federal case at this time. We're waiting for Judge Aiken to rule on their motion to dismiss. We're hopeful that she'll deny it and get back on the track to trial, and then the ball will be in Merrick Garland's court as to whether he's going to continue to fight the kids or actually fulfill what Biden has been telling the young people, that he wants to work with them, not against them, when it comes to climate. So it'll be a very—
How do you individually then support Biden, knowing that his justice system he, as a president, has done more for climate than any other president, and we're thankful for that. And at the same time, his Justice Department is fighting this like really important pathway. Like, how do you negotiate that as an individual?
Yeah, it's a tragedy. It's a tragedy. And it's a tragedy that the Department of Justice is not representing the people. They're representing the institution. So let's fight, while the world around us, what they called it in the Ninth Circuit decision was an environmental apocalypse. They said the current US policy will head us toward an environmental apocalypse. And here you have the Department of Justice defending us, so this environmental apocalypse can continue to happen. It's madness, and it's very frustrating. And there's been a number of congressional leaders that have called out DOJ with respect to their position in this case. And time will tell whether they will change that position and allow the kids to just, put on their case.
Mm.
So that's where we are with Juliana. The case that's, been gotten quite a lot of attention recently is the Held versus State of Montana case that was filed about 3 years ago. An incredible group of young people in Montana, all of whom have been affected in varying ways because of the climate crisis, whether it's being forced to stay indoors because of wildfire smoke. They now have a wildfire smoke season where all of their activities are canceled, and it's really deadly for them to be outside in the smoke. Changing their patterns with respect to being able to hunt and fish. Flooding has required some of our clients to evacuate their homes. So we went to trial in that case. So it was the first ever constitutional climate trial. And in that case, it took place in June of 2023. The young people testified for the first time in open court and told their story, how they're being impacted. The government was able to cross-examine some of them. And then the world's top climate and energy experts testified and explained why what Montana is doing with respect to promoting fossil fuel use is deadly for the climate system and what needs to be done in order to change that course. And we had pediatricians testify. We had mental health specialists testify. It was incredible. It was, like I said, the first time this has ever happened in open court. And then only a couple of months later, Judge Seeley issued a 104-page decision with findings of fact and conclusions of law, all in favor of the youth, finding that climate change, their constitutional rights to a clean and healthful environment, individual dignity, liberty, equality, personal security, they are all being infringed by government policy that allow them to enable fossil fuel production, and ordered them to cease that conduct immediately. So an incredible decision, the best climate change decision that has ever been issued, and really remarkable in how it gets the science right, in terms of how climate change happens, why every ton matters. So even though Montana is one of 50 states in this country, what they do matter because we're so far beyond the point of no return. So an incredible decision. And in that case, we have agreed with the defendants to have it go up on interlocutory appeal to the Montana Supreme Court before Judge Seeley decides the attorney fee issue. So that will be argued, assuming the Montana Supreme Court takes it, which we think is very likely given the importance of the issue and the fact that both parties want the Montana Supreme Court to hear and decide the case. That will be argued probably in the spring.
Well, that's fucking amazing for Montana. So now help us understand, what does a win in Montana mean for the rest of the US, and how do the state courts and the federal courts interrelate?
Yeah, so that's a really good question. So climate change cases are unique in that normally, if you have a decision in a certain state, it's pretty rare to be cited by other states. I mean, it does happen when there's novel issues, especially in the constitutional realm, like in education rights cases, for example. Many states cite each other. But climate cases are particularly unique because they really are citing each other in all around the world. So in Judge Aiken's decision, finding a fundamental right to a stable climate system, she cited to Urgenda in the Netherlands. The Canada Supreme Court has cited to the Juliana decision in their case involving a carbon tax. So there really is a lot of reliance on other courts in the context of climate change. So the Held decision, especially since it's based on a factual record, so not just theoretical legal analysis, there's facts in there as well. It really will be cited by other cases in other jurisdictions as legal precedent, even though, again, it's a state court decision. The other thing that's important is it shows courts that these kinds of cases are manageable. Many of the defendants come in with these arguments, oh, the issues are so complex. This would be 100-day trial. Judges can't figure out the science. It's too hard. We were in trial for a little over a week. We got all the evidence in. The defendants were able to put on their witnesses, and the judge got it. These cases are very clearly manageable. So I think that's an indication to courts that there are legal standards that can be applied. There are scientific standards that can be applied. And young people are able to give their testimony under oath. So I think that's another indication with respect to the case. Now, many people are focused on the fact that Montana, like Hawaii, has a constitutional right to a clean and healthful environment. And that certainly was a big part of the case, but it was not the only part of the case. The court also relied upon the fact that the Montana Constitution preserves the rights to life, liberty, individual dignity, and equality. And all of that really bolstered her legal findings. So for those constitutions, and there are many that don't have, including the federal constitution, that don't recognize a fundamental right to a clean and healthful environment, they do recognize rights to life, liberty, personal security, and equality. So to the extent to which that her holdings are applied in that context, that can also serve as important precedent as well. And then I think as a larger in terms of movement building, this case gave young people and others around the world a huge amount of hope that is desperately needed. I think our favorite part in our work is getting feedback from people. One of our colleagues, who's a law professor who's supported our work, he shared a photo of his daughter who was so excited about the win. She wore her OCT, Fundamental Right to a Stable Climate System t-shirt. She was just glowing. She was so excited and happy to see that, young people can be heard, their voices matter, and they can make a difference. So I think those things are equally important in terms of the legal ramifications. I think the social impact of the decision as well is something that we're continuing to see how that will develop and grow. And for example, Markey, Senator from Massachusetts, he wanted to reach out directly to thank the young people in Montana. It made that much of an impression on him as well. So I think you'll start to see this in other contexts.
So now, at least in the state of Montana, if the state pursues any policy in terms of its food system, its transportation system, its energy system, that doesn't address the climate impacts, are you saying that youth can then sue again because of the findings of the court?
Yeah, so young people now have a fundamental right to a stable climate system, and the court was really clear that the government has to consider climate change in any of its fossil fuel permitting decisions. So if they get a permit for a refinery or for a new coal project, whatever it is, a pipeline, they need to consider climate change. And because the science is so clear that every additional ton matters, they should be declining those permits and denying those permits. Whether that will happen in effect, there's going to be I envision a need for significant enforcement. And one of the reasons why we are going up to the Supreme Court is to make sure that there's clarification that they're the highest court in the state. and to give the state guidance with respect to how it's going to be implementing the decision. So there's still a lot to be done, but it immediately enjoined application of the laws that allowed the state to ignore the impacts of climate change. And when they don't think about climate change, they're certainly not going to use it as a basis to deny their permit. And we were able to establish at trial that in the last 30, 40 years, they had never denied a permit for fossil fuel production and development in the state of Montana, which is pretty incredible. And so this decision can and should be used to reform that conduct.
And so what does that enforcement look like? Are we do we need to grow the next generation of environmental litigators who understand how to use this court's decision to fight all of the manifold expressions of policies and programs that are increasing climate change?
Yeah, absolutely. Absolutely. And this is what the community needs to do, because now it's really in the community's hands. Now that they have these rights, they've been judicially recognized. Lawyers will play a part in that, but the community plays a leading role, because now that you're saying no to fossil fuels, you have to be saying yes to something else. And how that plays out in the state of Montana is something that will be in the hands of the community itself.
So, obviously the Center for Food Safety is deeply keyed into the ways in which the industrial agriculture model is also a major driver of fossil fuel use and greenhouse gas emissions. And so I'm wondering if you see potential applications for this law in also denying the permitting and expansion of concentrated animal feeding operations or the use of pesticides and fossil fuel-based fertilizers in agriculture.
Yeah, absolutely. And I'll point you to, so in Washington state, in the concentrated animal feeding operation permit litigation, we got a little win that, no one really talked about, but I think is really important. The court agreed with us that when issuing a CAFO permit, so it was a waste discharge permit, they have to consider the effects of climate change. And why that's important is that then gives you the agency an opportunity to say, okay, we're permitting this operation. Here are the massive emissions that are coming from it. I'm not going to permit that operation. So I think you need to go at it more indirectly when it comes to CAFOs, just because government has taken themselves away from permitting. There's much less government control over agriculture in terms of a regulatory context. And probably better than I, there's a long history and reason for that. And I think government control with respect to agriculture is largely in the realm of funding, right? And all of the money that flows to industrial agriculture. So I think there is a way to get government to shift course. And when you're looking at agriculture, it's probably less on the regulatory side and more on the financing side. So, if they're looking at whether to issue a loan or a grant, if they understand that they're constrained by what the Constitution requires, that should be used to reform their conduct.
So again, we've got an update on Montana. Where are we at in Hawaii?
Yeah, so in Hawaii, in April of this year, the court denied the state's motion to dismiss the case. The state hired off-island counsel to defend them in this litigation. And in the Hawaii case, we're challenging the operation of the state transportation system. So in Hawaii, transportation is the only sector of emissions that are going up. So in opposite direction of what the legislature explicitly has required. We like to say transportation is the flat tire when it comes to Hawaii achieving its decarbonization goals. So the state moved to dismiss the case, making the same arguments that are made in places like Virginia and Utah. And, we've seen in Montana, countless other states, the state made those same arguments and the court soundly rejected them. And that case is headed to trial in June of 2024. And Hawaii, I think, is unique in that, Governor Green is very committed to addressing climate change. And we're currently in settlement negotiations. And it's our hope that the governor and Ed Sniffen, the director of HDOT, will want to work with the kids and come up with a really incredible, creative, first of its kind solution instead of going through the contentious litigation process. Whether that will happen, I don't know. It's an incredible opportunity for Governor Green, and we're hopeful that he'll see that. Hawaii is facing many, many challenges, including the fires that just happened in Lahaina and on Maui. We had 2 plaintiffs who lived in West Maui and were directly affected by the fires. So we understand the challenges that come. And I really respect Governor Green has recognized the connection between the fires and climate. So I think this case gives him an opportunity, and the young people certainly want to work with him and support him in his efforts.
So where else we got? Utah, Virginia, maybe just a quick overview of updates, because I think we're running out of time.
Yeah, sure. In Utah, we'll be arguing. It's one of our first cases explicitly focused on the right to life, and the right to life encompassing health and safety for young people. And we're challenging the state policies that explicitly direct the political branches to maximize the use of fossil fuels. That case will be argued in the Utah Supreme Court in the coming months, which is incredible to have that case at that venue at this point in time. In our case in Virginia, similarly challenging laws that promote the use of fossil fuels, that case will be argued in the Virginia Court of Appeals either the end of this year or early next year. And then we're waiting for a decision in our La Rose versus His Majesty the King case in Canada from the Federal Court of Appeals, which could come any day.
So cumulatively, you're making a ton of headway. You're starting to see judges get it. You're getting an evidentiary record that other courts are going to look at. What gives you the energy and hope to continue on?
Because I think we're going to win. And when I say we're going to win, I mean we are going to have the will and ability to really change the systems that are causing climate change. So talking to the impact experts, very depressing, disappointing, hearing what's happening to corals. What Hawaii is going to be experiencing these next few years because of El Nino is extremely alarming. But then when you talk to the energy experts about what is possible now in terms of transforming these systems, so Hawaii does not need to be the most oil dependent state in the nation, which is hard to believe, but that's true. There's other ways to do that. And I think for young people, they really see that vision. It's much easier for them to see that vision and not buy into the need to be locked into the use of fossil fuels. So I think we're starting to see that vision come to pass, and our hope is we can do it fast enough. The switch to El Nino is going to bring very challenging times to our life support systems on this planet, and we've already seen that in Hawaii, in Libya, just recently with the floods, the fires in Canada. So we've really got to move as quickly as we can, and hopefully it will be treated as the emergency that it is.
Well, that was awesome. Thank you, Andrea. I personally am curious what the defense argues. Are they arguing that climate change does not exist, or do they agree with that and they're just arguing on constitutional grounds?
Yeah, that's a really good question. So the defendants in our case, their defense arguments have evolved. And what's interesting is they're almost identical to the arguments that government made when defending cases like Brown versus Board of Education. So with respect to climate change, they started saying, well, the injuries they're going to happen far into the future. They're not happening now, so you're not being injured. They're happening into the future. That has shifted. They really recognize that young people are experiencing injuries today. They certainly will get worse in the future, but they're experiencing injuries today. Now they're saying, but government isn't responsible for those injuries. So they like to argue that they're not the ones causing the injuries. Other people are. Climate change is a global problem. And so because everybody's responsible, nobody should be held judicially accountable. That's a common argument we see. They also argue that courts cannot issue a remedy since climate change is a global problem. I guess they think everybody, and I think this really resonates with our young clients because, they've heard the old adage, if everyone jumped off a bridge, would you? And that's the government's argument. Everybody's jumping off the bridge, so we're going to do it too. So I think the kids sort of laugh that argument, and fortunately, judges are starting to see it for what it is as well. The other argument they make is that this is a political question. So courts have no place in protecting constitutional rights of people. And fortunately, there's 300 years of precedent in this country that that's incorrect. That's exactly what courts are to do. If the legislature is charged with making laws and ensuring that they're constitutional on their own without any oversight, we become a very different kind of democracy. And that's probably not even the right word to call that system of government. So those are the primary defense arguments that we see. And again, very similar to the arguments that were made by government in Brown versus Board of Education, which I think is tragic in many ways. I wouldn't, as an attorney, want to repeat the kind of arguments that were made in defense of segregated schools, but those are the arguments that government is making. Montana was a little bit unique in that they did appear to question whether climate change is real. Some of the experts that they had enlisted seemed to suggest that they were questioning the science of climate change, but ultimately they weren't put on the stand. So when it came to the actual trial, they didn't present that evidence in court. So, I think they saw it for what it is. And that's, you can't perjure yourself in a court of law, and climate denialism really has no place in a court of law, let alone in our society these days. The science is so clear.
I think that's a good place to end. Thanks so much.
Yeah, thank you, Ashley. It's so great to talk to you.
The Hero's Journey is brought to you by the Center for Food Safety. Production by Julia Rani and Ashley Lukens. Editing and social media by Amanda Lillibridge, Duray Shin, and Annalisa Camacho. Theme song by Walker Lukens and Adam Mason, and audio engineering by Adam Mason. You can find us across all podcast platforms and follow us at Center for Food Safety on Instagram, YouTube, and Facebook, and CFS True Food on Twitter. We're on the web at theheroesjourneypodcast.com. Do you have a hero you'd like to see on the podcast? Fill out the form in the show notes or email us at theheroesjourneypod@gmail.com. If you enjoyed this podcast, like and subscribe, and make sure you'll never miss an episode. We'll see you in a few weeks.